Ladies and gentlemen, the issue I'd like to address is the problem when cases involving children need experts' opinion, and the experts in modern days obviously use modern technology to support the work. Yes, uh, it's quite clear that modern technology not only helps with analyzing evidence, but what's very important in cases involving children, it significantly speeds up the proceedings. Yes, the victimization of the child appears not only for the crime itself, for the illicit act, but also through this how the proceedings is organized, especially if it takes too many time, if it takes simply too long. So these are obvious benefits. On the other hand, the problem with new technologies, with technology, is quite basic, and it brings us the problem of our laziness. Mainly, new technologies makes us lazy. Yes, new technologies makes us to surrender our analytical abilities, needs, simply ending with the result where we are not interested, where we don't understand how this result was presented. In criminal cases, in every proceedings, I think, from the very beginning of using experts' opinions, we have this basic problem that even if the case is extremely complicated and where the court essentially needs the help of an expert, at the very end, it is always the court, the panel of judges, or as it's now mostly in Polish courts, one judge. It's the court, the judge, to give the decision, not the expert. So I think in Hungary, I suppose you share the same problem we share in practice, when the court simply wants the expert to solve the case for him. And our efforts as lawyers, as attorneys, defense attorneys, and whatever, in such situations come to the effort, make the judge think on his own critically about this what experts presents. It is one of the fundamental requirements of evidence law that even if the expert's opinion is the most important evidence, and even if it deals with most complex issues, it has to be able to be verified by a non-professional, non-expert. The non-expert, the judge, the parties, have to be able to understand how the conclusions of the experts occur, how they are presented. In the same time, the expert's opinion cannot be uprooted from the evidence, cannot be conflicting other evidence. Now, this general problem appears through all the decades of our practice, but especially now it is doubled when expert is not only an expert by himself, where there is this risk that the court, the parties won't be able to understand him, but when the expert uses this modern technology. So this problem of understanding becomes double. We have to understand the expert, and we have to understand the technology the expert uses. As the court cannot waiver his decision and simply put the decision of the case to the hands of the expert, at the same time, the expert cannot surrender his analytical skills and put it dependent only on the algorithm or artificial intelligence. Oh, sorry, not this slide. So the widely discussed problem is how the artificial intelligence and modern technologies may support experts' work. Yes, the obvious problem is the risk of contamination of evidence in such situations, the inability to verify the algorithm itself, the way it brings conclusions, especially if we deal with cases such as analyzing AI-created child pornography or such issues. Just as an example, I already signalized this problem during our previous conference. In the Polish legal framework, we have this problem that expert cannot surrender his opinion, giving it to the machine. Yes, and the very problem with this was when using polygraph in Polish criminal proceedings. Under our legal framework, which is Article 199A and 192A of the Polish Code of Criminal Proceedings, in special situations, a polygraph may be used, but it's never an evidence of the polygraph, but it is evidence of expert's opinion who analyzes the polygraph, and his expertise on the results or the opinion itself. So it can happen, but in the same time, we have a very long judicial analysis that this expert has to be able to deeply and clearly present the result, discuss the results, what the machine produces. Yes. So we may use an analogy to a situation where the expert will use programming or even a polygraph using elements of artificial intelligence technology, and we may ask a question: will he be able to give such a thorough explanation how this algorithm, how this programming works? And sorry. So yeah, this is the legal basis. So we obviously have general legal framework how to control the expert's work. We may evaluate his skills, his discipline, but in the same time, under Polish law, there is no any central committee or any central organism which is to verify the expert's abilities and the standards. Yes, it is always court's decision to use somebody as an expert. He may be a permanent expert from a list of a district court, but he may be also an expert ad hoc, where when it goes to modern technologies, it appears more standard basis. So how to decide whether certain new technology used directly or especially through experts' opinion may be presented in proceedings as an evidence? I suppose we haven't created a standard on the Polish law yet. We have those old and deeply discussed standards from American law, this double standard from Fry and Daubert cases, where those elements where those criteria were created by the courts. Yes, so this general acceptance of the method, its falsibility, its diagnostic value, its verification through publication, and the acceptance by the scientific community. The other problem, technical one, is quite often that experts' opinion, especially using new technologies, may be presented not only by individual experts, but under Polish law, they may be also presented by so-called specialized institution, which quite often is a really blur concept, where the institution itself might present certain level of specialization, but the very person who produces expert's opinion not always. And in such situation, I would like to address the provision, one of the fundamental provisions used for verification of experts' opinion on the Polish Code of Criminal Proceedings. It's Article 201, which states that if the expert's opinion is incomplete, unclear, or if there are contradictions between opinions, the court may once more call the same expert or use another expert's opinion, yes, new opinion. And my personal view is that in situations when experts use new technologies, use artificial intelligence, and where the conclusions of their opinion do not clearly present how this technology led to the results they present, supporting it by the titles and so on, the court should definitely use this article, and especially the element of the unclearness of the expert's opinion. So under Article 201, the court should stress out that the requirement of clear presenting the conclusions and the analysis of the technology used must be exercised. Because if we don't do it, and if we accept a situation where experts' opinion is widely used and it's not criticized, and the experts depend on technology itself, it really takes deciding a criminal case totally out of the court and out of the personal competence of certain judge. It is not even then the expert who decides the case, but the program, the technology that the expert uses. That's all. Thank you.